Hello and welcome everyone to the National Veterans Small Business Coalition's Charlie Mike series, sponsored by BAE Systems. We're thrilled to have back our legal beagle, Chris White from Clark Hill. And Chris, what are we talking about today?
Thank you so much, Marie. And again, thank you to BAE. Appreciate them allowing us to do this. Today, we're going to be talking about the navigation of legal complexities, which specifically means considerations you will want to think through as you're deciding whether or not you need an attorney, whether or not you need a specialist, and what the process is like to retain an attorney and to get one on your side of the aisle.
Cool. Well, that sounds pretty exciting. I am going to go into stealth mode here, and then, question fairy will pop in from time to time like before. And so I'm looking forward to learning about why I may need legal counsel. So stealth mode.
Sounds good. Thanks, Marie. So as I said, this is titled Navigating Legal Complexities. Why and when do GovCon's benefit from legal expertise? Again, I am Chris White. I am an attorney with Clark Hill. We're an 800 attorney law firm that spans the U.S., Mexico City, and Dublin. My specific practice area is government contracts. We operate as life cycle strategic advisors to GovCon's everywhere from forming and restructuring businesses to drafting and negotiating agreements and analyzing FAR, DFAR clauses for compliance through bid protests and contract claims. So today, however, I am just trying to draw on that expertise and from the legal perspective to help demystify somewhat of why you need an attorney, when you may want an attorney, and what the process is like in retaining an attorney and the considerations related to that. Most importantly, since this is not live, Maria will be filling in as the question fairy because I always encourage questions throughout this. And that also means once you've watched this, if you do have more questions for me, please don't hesitate to email me. I'm happy to field those questions as they come in. The agenda for today is when should you consider hiring an attorney? How does an engagement process work? Should you be looking to do an hourly or retainer-based engagement, and why would a retainer be necessary? How to find the right attorney and what to consider, and then red flags, considerations, and when to walk away. This doesn't mean that there's a bad attorney out there. This just means that there's a chance that the attorney may not be the right personality fit for you. And it's important for you to have a trusted advisor on your team that you want to work with and works properly for you and the needs you may have. So first off, when do I need an attorney? And should I consider a specialist? When discussing this, you want to consider what stage is your company? How new are you? How many contracts are you looking at? How many agreements are you working through? I say this because many times small businesses rightly use friends, use family, use acquaintances, use whatever as a general attorney that helps them by structuring their company documents. They form the company for them. They draft a basic operating agreement or articles of incorporation, and they help them out with their basic agreements, reviewing an NDA, what have you. That's totally fine. In fact, that's encouraged. At early stages, you want to find somebody that most importantly, you can trust and that you like, and that the price is correct for where you're in the stage of your company. As you start to increase, whether this is a very frequently used sub, or once you start becoming a prime contractor and you have subcontractors you may be hiring, you may want to consider, do I need a specialist in the GovCon space? I say this because there are many attorneys out there that are litigators or corporate transactional attorneys that delve occasionally into the space of GovCon. This means they do your general employment litigation or breach of contract litigation, but every so often they might do a bid protest, or every so often they might draft a contract claim before one of the board's contract appeals. Conversely, from the transactional and corporate, they may periodically look at a teaming agreement or joint venture in the private space. But when you get into the public space, maybe they don't have the right experience for what the SBA requires or what the FAR requires. Or when they're looking at a prime or subcontract, what FAR clauses are in there, which ones apply, and how do you know those apply to you, and what do you have to do based on that clause applying to you? And those are the times when it's probably worth considering a specialist. And I'm not saying you shift entirely to a specialist, but it's worth having someone in your proverbial Rolodex that you can reach out to if you have a GovCon specific question that lives and breathes the FAR and lives and breathes GovCon to help answer those questions for you. This is also true based on the number and frequency of contracts and agreements. Again, if you have a generalist that does a lot of standard master services agreements or standard contracts, that's wonderful. But if you start churning through a lot of joint ventures, mentor proteges, and teaming agreements, that have to be compliant with the US government requirements, you may want somebody to at least do a small level of effort to look at that contract to ensure it's compliant with the federal requirements, even if they're not the one drafting the entire agreement for you. It's worth the consideration. I always tell people the old adage of buying a boat. When someone goes looking for boats and they say, oh, how much is this? The answer is, if you have to ask, you probably can't afford the boat. Here, it's almost different. When you're thinking around, what would an attorney think? Or if you start thinking, can I afford an attorney? You've probably reached a point where you can't afford not to have an attorney. There are situations that come across all the time. Somebody comes to me and it breaks my heart because they're, oh, can we do this? And it's like, yes, you could have done this, but it's not timely now. And now I can't help you. You've missed the bid protest window. You've missed the statute of limitations. Or I wish I'd had you look at this agreement. I entered into it and I paid all this money and they breached, but the language was disfavorable to me. And now I don't have a recourse. I'm just out that money. I really wish an attorney had looked at it first. These are the things that we try to avoid. I view that coming back from my Navy time, preventative maintenance versus repair work. It's much like changing your brake pads rather than having to grind down rotors. One is relatively cheap, one is much more expensive and takes more time. So the whole goal here is to find an attorney to help avoid problems before they turn from that mountain into a mole, from a molehill into a mountain. That was backwards, but from a molehill into a mountain and get way more expensive for you. You want someone to help you mitigate that or give you the risk analysis of what you're accepting or what you're proceeding with. Marie.
Okay, can I, as the business owner, have two attorneys, kind of like my corporate attorney, and then hire someone like you that focuses on just the GovCon? Have you seen things like that during the course of? Okay.
Yeah, so I've seen that in a variety of different ways. I've seen that where I know clients of mine that have 5 different law firms that represent them. They have a law firm that's there either if they do something both federal and state. They have multiple law firms that handle this grouping of states and then this grouping of states and someone that just does federal for them. So I see stuff like that. I also see it where they're like, you know what? We've had an attorney we've been using for 20 years. They do everything for us. But that attorney's like, oh, you have a GovCon specialist. That'd be great. And then me and that attorney start emailing directly and they say, hey, Chris, just put together this agreement. Can you take a look at it to make sure it's compliant with the FAR? And I pop in there. I look at just the sections they're asking me to look at because that attorney's asking me to provide my specialist focus on a little area. I just mark up that small area. I send it back to the attorney. They review it. Once they're good with it, they send it all back to the client. And no harm, no foul. Attorneys should be able to work together. If an attorney is hesitant to work together, it can be one of those red flags. But it also, it's just requires communication and the client identifying, who they want doing what level of work, or saying, hey guys, or, hey ladies, whomever, I need you all to figure out which chunks of work are you each doing. You can do that. And you can do that where at Clark Hill, being a large firm, if you hire me as a GovCon, but you have a labor employment question, I bring in a labor employment colleague of mine at Clark Hill. Same thing with tax, same thing with, M&A. We do it all in-house, but that doesn't mean it has to all come over to us. I work with other clients and they have attorneys that they have a labor employment attorney that they adore. They do all the labor and employment work. They just send me the GovCon work, and that's fine. We each have our lanes. We stay in our lanes. And it's ultimately the goal, the bottom line goal is it's not about the attorneys. It's about the client. And so what we want to do is make sure the client's getting the right advice to make the right risk decisions, to know what they're doing, to know what their decisions may cause or may not cause, and they can decide acceptable risks to move forward.
Cool. And so then the business owner would say, hey, Chris, I want you as my GovCon specialist, and Freddie, I want you to be my labor attorney, and maybe Harriet is the tech transfer or a licensing person
or whatever. Yeah. No, exactly. Cool. And they do that, and that happens all the time. And it's very easy to do. As I said, I routinely get stuff over, and it's from another attorney for the client. They say, hey, here's an agreement. I need you to look at paragraphs 1, 7, 13, 14, 15, 19, 21, and 27, and let me know your thoughts. So I go in there and I mark up the document on those paragraphs alone, put in little comment boxes and fire it back and say, I completed my review of the paragraphs you asked. And I put in my own qualifying language. I, however, did not look at any of the paragraphs you'd asked me to look at because should something be wrong in those paragraphs, I don't want the malpractice risk of somebody coming back and saying, well, you looked at the document. It's like, well, in my limited scope, I looked at the document. And so that's why I say it needs to be carefully articulated, because A, protecting us as attorneys for any claim against us, but more so, we don't want anything to fall through the cracks. Marie, if you're looking at it and I'm looking at it, and we don't want to be like, oh, I thought you were looking at paragraph 23. No, I thought you were looking at 23. We need to make sure the client's covered, and we communicate amongst ourselves to understand exactly what each one of us is doing.
And so does the business owner pay you separately from the labor person, or is that all kind of figured out up front? Or does the labor person, you're the sub to them, or they're the sub to you? How does that kind of work?
That's a very good question. So in some realms, if you're local counsel, you would be paid by the other attorney, because that attorney's hired you to be local counsel. And that generally means that's generally a litigation thing. It can be a corporate thing, but it means that broader attorney has asked you to do a little bit of work. You send the invoice to the attorney, they add that invoice to their invoice, and they send it off to the client, and then the payment flows through. We generally prefer just our own engagement, because we want to have the engagement letter with the client. And so that establishes attorney-client privilege with that client directly. And it means that whatever we're talking about is not being opened up to or discussed amongst other people. And so it limits down, and then the invoices come directly to us. So for the vast majority of situations, you'd have an engagement letter with your labor employment attorney or firm. You'd have an engagement letter with me and Clark Hill for GovCon. You'd have an engagement letter with whomever else for IP, what have you. And so each one of your attorneys would be operating independently, which somewhat makes sense, because unless we're all working on the same project, no one attorney knows what work the other attorney is doing. So who knows when to wait for what invoice from what person, or how does another firm validate the invoice of a firm if they weren't working on the same project? And so it's generally individual relationships just based on that specialty. And then the client elects when they do or don't send something to which attorney for work. And they're only billed for the time that they've, effectively approved the work by sending the work to that specific attorney.
Yeah. And the other important factor that you mentioned is attorney-client, privacy, the privacy or the confidentiality between that two. That would be another factor for a business owner to kind of think about as well. Cool.
Yeah,
All right.
It gets tricky if the relationship's with another firm, because then technically that other firm's your client and not the actual client. And so it can get a little tricky that way.
Yep. Okay. Well, I'm going in stealth mode again.
Sounds good. And the final part of this, when you're hiring an attorney, is when you're asking the question, this is that risk mitigation. What does this section mean? What does this clause mean? What does this language mean? And what does it obligate us to do? That's where you want to have an attorney with the requisite level of specialty to be able to succinctly articulate to you, what does this mean? So this FAR clause means it applies to this type of contract, this value of contract, and it means you must do X, Y, and Z. Oh, what does this NDA mean? Oh, well, that means that this type of data is included, and you have to control it in a certain way, and you can't say it to certain people. Oh, but what about my sub? Let's take a look at the NDA. Someone advises whether or not you can bring it up to your sub. In those situations, you want someone who can help parse that for you into plain language rather than the legalese that is generally drafted. All right, so then the engagement process. Hiring an attorney is establishing a relationship with somebody. You are interviewing that attorney just as much as that attorney is interviewing you. That means you want to do an introductory call, or you can start out with introductory email, but you ultimately should do a call so you have a chance to discuss what you believe your legal needs are and what your questions are. That also opens the door for the attorney to ask some questions to better understand the circumstance and to flesh it out a little bit more so that you can create what's called a scope of representation. This means that you should know from that point precisely what that attorney is or is not agreeing to do for you. And that helps, you understand what costs are going to be incurred, what you do, like what can you reach out to that person to get advice with. Then the law firm has to do what's called a conflict check. We do this because we have a bunch of clients, and we need to make sure that we don't accidentally get into a situation where in litigation, we're litigating against ourselves because we're representing both sides of a deal, or we're negotiating an agreement and we're representing both sides of the agreement. So we need to make sure we don't have that conflict. If there is a conflict, we can go through a waiver process if we think it's appropriate, but we just make sure that we are protecting you to make sure that we are only focused on your best interest. Once the conflict check clears, we do what's called an engagement letter. This engagement letter should clearly articulate the scope of work. Now, sometimes for me, that scope of work is government contract counsel. That means you've asked me to advise you on everything under the sun related to your GovCon practice. That could mean I'm helping you restructure your company from an LLC to a C Corp or an S Corp election. That could mean I'm restructuring your company based on equity interests amongst different partners. That could mean I'm drafting teaming agreements, joint ventures, mentor protege. I could be negotiating primary contracts. I could be negotiating subcontracts. I could do bid protests. I can do contract claims. Anything that comes out of that, I can be doing for you, and that's fine. We can have a very broad representation, or it can be, Chris, I need you to look at one NDA for me. And so then the scope of representation is to look at the X, Y, and Z NDA, and that's the full scope of representation. All of that's fine. It just depends on how much you think you're going to continue to use the attorney after, that initial scope. Most engagement letters allow for a scope to be expanded upon mutual consent between the two parties. I recommend that so you don't have to go through a full engagement process a second time, close out one file, open up a new file, but it's ultimately your comfort level, and you should be comfortable and understand what your engagement letter is committing you to and what your engagement letter is committing the attorney to do. That includes, how are they billing you? How much are their rates? How much is the retainer? Which we'll talk about on the next slide. But all of that should be in front of it so you understand the financial burden that this engagement with an attorney might impose. Once that engagement letter is executed and the retainer is paid, it's off to the races. From that moment, they're your attorney and they can begin working for you. So getting into the retainer, so getting into this monthly retainer, hourly fee structures. You want to evaluate what your need is. You want to ensure you're receiving the right bang for your buck. We call this value add at Clark Hill. That value add means as much as we recognize as an attorney, like any professional service, you're getting a bill from us. We impose a cost. Whether we win a bid protest for you and you get a contract, we still have a cost that makes that contract slightly less valuable because you had to pay our legal fees. It's always a cost. But what we want is when you look at that bill, you look at it and go, yeah, that was worth it. And that's always our goal, for you to recognize that the amount of money we're charging aligns with the level of effort we brought forward to you and the level of benefit we brought to you. That doesn't mean we always win. And sometimes it's a more bitter pill to swallow than others. But at the same time, as you're going through the process, it should be recognized that, the person is giving you what they're charging you for. Some people go the route of what's called a fixed amount monthly bill. And some people call that a monthly retainer method of charging. This means that you worked out with the attorney that every month you're going to pay them $500, $1,000, $2,000, $3,000, $4,000, $5,000, whatever it is. And they will do work as much as you ask or as little as you ask, and you will get a bill for that set amount every single month. I generally don't recommend this except in limited circumstances. I say that because we've done it before for a client, monthly retainer, but that's because we had an agreement with the client that every Thursday, our attorney would be sitting in their office on site for 8 hours. And during that 8 hours, that was their in-house counsel. They had an attorney that anyone could come to with any legal need. And for 8 hours, that attorney handled legal needs nonstop for just one client. The retainer structure meant that they were charged for 8 hours times 4. So 32 hours, per month. And they were paying for 32 hours per month. That made sense because that's all they wanted. That's all they needed. They could budget for it. It was built in and budgeted. Outside of that engagement, I don't recommend it because I guarantee you that attorney can calculate what they think is a safe number to charge you every month based on your level of work. And every retainer fee agreement includes the ability to adjust that. If you start paying them $4,000 per month, but every month you're asking for $5,000 worth of work, they will increase it to $5,000. The attorney is not going to lose money on this. Most attorneys will do the converse. If you're paying them $4,000 a month, and every month in and out, you're only accumulating $3,000, they'll adjust it down. But the adjusting down is risky to the attorney, because what happens the next month you ask for more. This is why, in general, I recommend the next one, which is hourly billing. This is how I do 99.9% of my work. I bill you every 6 minutes, or 0.1 hour. That means if you ask me to do a half hour worth of work, and that's all you ask for the month, you get charged for a half hour worth of work. If you ask me to do 40 hours worth of work that month, you get charged for 40 hours worth of work for that month. If you ask me to do nothing, you get charged for nothing. You don't save money via a monthly retainer. You save money by doing an hourly billing and only being charged for the level of effort and the amount of work that attorney has performed for you that month. Marie.
I'm back. Okay. So I have a contract that I want you to review, but I didn't, let's say I saw this contract at the end of a month and I'm like, yeah, I'm going to go after this. I go ahead and I pull together a proposal and start, doing my, my response and things like that. And it's like, oh, I'm just going to pick, the deadline is, for the review and feedback to the contracting officer, let's say, is the 15th of the following month. How hard is it for me to get onto your schedule so that I can have you review, or not just you, but any attorney with that specialization of GovCon, to get a response, to be able to pull together your expertise into my proposal? Or should I, as the business owner, in my proposal strategy response, figure out the lead time I need in order to get feedback from, an attorney or even an accountant or a pricing analyst, if I'm even going to that level as well? So in order that I meet the proposal submission deadline, where I'm coming at here with,
So, yeah.
Because you guys are busy, right? You guys are, GovCon, that's a unique niche. There's a specialty. I guess what I'm getting across too to people who may be listening to this is that I can't just pick up the phone and say, hey, I have a deadline next week. Can you look at this contract and give me feedback, within 24 hours or something like that? I mean, it's.
Yeah, no, you're right. So generally speaking, during the week, conflicts check can be done same day to next day. And so that's 24 to 48 hours. Now that's contingent upon, we have our intro call. You're like, Chris, I need your help. Proposal, hot deadline. I'm like, okay. I fire over our conflict check questions to you. You get them back to me. I submit them right away. Sometimes same day, if not next day. That's done. I fire off the engagement letter to you. You sign it. You get it back to me same day and pay the retainer. I can start working that very next day. It all depends. Like, I prioritize my work based on deadlines. So if I'm working on someone's agreement and, both sides are eager to have an agreement done, but it's just they want it done. Meanwhile, a bid protest pops up and I have I have 3 days to submit it, or you cannot submit it. I'm going to slide that bid protest ahead of the agreement. I'm going to work on the bid protest first. And so that I can factor in, that I can evaluate, but
okay.
Coming to someone and saying, I need this done in 24 hours probably is not really feasible, because now you're asking someone to not only run conflicts, engagement, blah, 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 but you're giving them 24 hours to try to wrap their head around a set of facts that they have no exposure to previously. And it's risky for the attorney, because now I'm being asked to give a definitive, defensible, legal thought and opinion, but I'm not given a lot of time to get to that spot. And, sometimes that means I need to look at your documents, and I need to have some time just to digest and think them through, because you read it all and you're processing a lot of data. So sooner the better. But at the same time, I certainly have had a client come to me and said, we need a bid protest filed tomorrow. And we got it done, and we had it filed the very next day. So it can be done. It just,
But the previous relationship has already been established with you, the attorney. It isn't like I'm just picking up a cold, I'm just not cold calling you to say, hey, I have this critical thing going on and I need you, like, to respond today or
Correct.
tomorrow or whatever. So there's already been a
I've done 72
relationship.
hours. I've done 72 hours on a new relationship. I probably couldn't. If you came to me and said, "Hey, I need something done in 24 hours," and it's our first chance to speak. I mean, I guess if we did conflicts and you paid me my retainer the very same day and we're ready to go, I could do my very best effort. There'd be a lot of qualifiers and caveats in there of, like I'm doing the best I can considering the time constraints you put on me. If you come to me with a bid protest, we've never spoken before, I'm probably gonna be like, sorry, that's just probably not enough time. I'll try. I'll look at it. It depends on the circumstance, but there's some times where that bid protest is based off of hundreds and hundreds of pages of documents. And in order to do a meaningful bid protest, I need to get through all of that so I can properly draft a 20-page protest. On top of that, include all the exhibits and the citations to the right part of the exhibit and make sure I'm not missing something, because if you submit it too abruptly and you miss a document and there's an immediate flaw in your protest and it gets kicked out because of that flaw the very next day, like it's not necessarily defensible. Oh, they just didn't give me enough time. It's like, well, if you didn't have enough time, you should have said no. And that's our rules of ethics, say that if we legitimately cannot get through something and do a good product in that amount of time, we are ethically obligated to say no, because people rightly, and we want them to have a reliance and an expectation that when an attorney says, yeah, this is ready to be filed, that it's good and it's ready to go and it's their best situation. And if we're not given the right opportunity to do that, it creates a tricky situation. Right.
Yeah. And if somebody did that, that could be one of those red flags that you're gonna.
Yeah. We start to wonder, were they with a different attorney? And then there's some document in there and that attorney said, yeah, you have no grounds. Oh, we want to file it anyway. And they're like, well, we're not, and we also are ethically prohibited from filing frivolous lawsuits and frivolous, bid protests. So do they find a reason it was frivolous and say, we're not going to do it? And now you're jumping to the next attorney saying, oh, they don't have as much time. Maybe they won't recognize it's frivolous. And so those are things we start to wonder about and we start to get curious about as well.
Cool. All right. Thank you.
Sure. So after hourly billing, next is fixed fee, flat fee. This is usually done where I'll use NDAs, for example. If you come to me and you say, Chris, I churn through 10 NDAs a month, can we just structure it up where, you look at this NDA, you've drafted the first one, but now that it's drafted, you just need to do minor modifications on it where there's a set value per NDA every time and it's not based on hourly. Then yeah, we probably can reach that agreement. We've drafted the full NDA. NDAs aren't super lengthy. So, we cap it at 2 hours per NDA. And you just know that every NDA is going to cost what 2 hours worth of time costs. Then you can structure that. And that's a fine fixed fee. You send over 10 NDAs in a month, you get charged for 20 hours worth of time. And you know exactly what to expect at the end of the month versus one NDA was 2.7 hours and one NDA was 1.3 hours. And maybe at the end of the month, you're not quite sure where you're going to fall out. Maybe it does average to 2, maybe it doesn't. So we can provide you a little bit of certainty, a little bit of guarantee. Similar to that is not to exceed. That's done hourly up to a certain dollar value, then it stops. Usually there's a contingency in there where once you hit that not to exceed value, the attorney lets the client know where they're at and how much more time they think it would need to get it done to the proper spot. Otherwise, the risk associated with stopping as is or X, Y, and Z, and the client can make their determination from there. These aren't used a ton, but it is an option out there, something that you can consider talking about with your attorney. Finally is contingent. These are not done a lot in GovCon. I've seen them done in very large bid protests for certain large firms that are willing to take on all this risk. So a contingent fee effectively means the client pays nothing throughout the course of the representation. In exchange, the attorney gets 33% of any monetary gains that come back. You'll see this all the time when you look at personal injury, plaintiff attorneys, stuff like that, what you see on TV with massive settlements and people fighting for this huge settlement and classes of people because they get to collect. If the jury awards 300 million, the law firm walks away with 100 million. And sometimes it's done where it's 100 million plus their fees, so they may walk away with more than 100 million. So I've seen that in some spaces with bid protests. If someone's hired contingent to protest something so the contract award comes to them, then the law firm, gets some portion of the value of that contract as its fee. Again, not super common, but something that can be out there. You can have a conversation with an attorney about it, but it's not done very frequently. And so there's now a difference, and this is what we talked about earlier in the engagement process, the upfront retainer. This is totally separate from a monthly retainer billing process. What this means is a client, in order to engage that attorney, pays an upfront retainer with the engagement letter. This is done and held in trust for the client. So that money is the client's money. It's kept in the law firm's trust, but it's held for that client and returned to the client at the end of representation, or sometimes at a certain point down the line, once trust is established, relations established, that trust, that retainer will be returned to the client. It serves as a bond or a surety to guarantee a certain quantity of work for the attorney. That means if you come to me, you ask me to do whatever for you, I take a $5,000 retainer, and you ask me to work on the first agreement. I do the agreement. It's $4,200 worth of work, and you go, thanks, I never hear from you again. Rather than having to keep chasing you and hoping to collect $4,200 sometime later, if I don't hear from you after a certain period of time, I send a note saying, well, unless I hear from you by this date, we'll consider the representation ended and close the account. We'll credit the $4,200 against the trust account and return the outstanding $800 to you. It means we still get paid. You'd be surprised how often clients do try to walk away with the goods and not want to pay. But this means that we don't have to chase them or have to take on any bad press of law firm suing a client trying to get paid. But this is not something that, as work is done, every monthly invoice goes against this retainer. It's something that just stays on file. You pay your monthly invoices, and then at some point in the future, that retainer is returned to you. This retainer is calculated based on some portion of the estimated work or the amount of work to be completed in a certain period of time. If you're looking in the M&A space, if you're looking at bid protests, things that have an incredible burn rate early on, the retainer is likely to be higher. This means that if the total scope of representation for an M&A is going to be $60,000, but of that $60,000, $40,000 is going to be chewed up based on work in the first 20 days, you're probably going to have a $40,000 retainer to make sure that first month's bill is covered. Similar with a bid protest. Many bid protests, you have 10 days from the date of you knew or should have been known. If that's coming in, you're probably going to have a significant upfront retainer for that bid protest because all of the work's going to be done in the first 10 days. And that means that the firm doesn't want to be on the hook for some significant amount of legal fees without having a retainer to cover those and provide some security or comfort that the work will be paid for. But again, this is your money. It's not a sunken cost. It will be returned to you at some point during the representation or upon concluding the representation. And by concluding the representation, that also does mean if the client elects they want to move to another attorney or doesn't want to pursue the whatever legal work anymore, they just decide to call it quits. Effectively, they want to fire their attorney or move on to another attorney or whatever you want to call it, part ways, break up. That trust money will be returned to you less any outstanding invoices. So how do we find the right attorney? Simplest way, obviously, is web searches. Hop on good old Google and say, best GovCon attorney, Washington, D.C., Lansing, Michigan, Miami, Florida, what have you, and see who pops up there. Like anything else, web searches have some risk. People can pay to have their names popped up higher. There are certain services out there that people pay to be listed on, get accolades. So those can pop up. So you do want to be aware of that. Not just because someone pops up first does that actually mean they're the very best. It could mean that they're the very best, or it could mean they paid some amount of money to be put at the top of the web results. Much more frequently, we see referrals from peer companies. You meet somebody at a conference or you see somebody all the time and you're like, hey, man, who does your GovCon work? And they go, such and such does your GovCon work. And then you reach out to that attorney, you start talking to them. I say events like this next. That's because I've done this presentation for NVSBC engagement dinners, lunches. I presented it at VETS 25, which was another phenomenal conference. If you didn't attend, you should attend VETS 26. But those are great events to talk to people, to meet attorneys, or to talk to people and ask them about the attorneys they use. Family referrals are very common. Reach out to father, mother, brother, sister, cousin, aunt, uncle, niece, nephew, and ask them about attorneys they know and see who they recommend. Similar with friends, golfing friends, drinking buddies, bowling buddies, shooting buddies, hunting buddies, what have you. Talk to them. Who do they know? Ultimately, you need to remember that when you speak to these attorneys, you're interviewing those attorneys just as much as they're gauging whether you're the right fit for them. When I say whether or not a client is the right fit for an attorney, what I mean by that is, are you asking them to do an area of work that is actually their specialty, or are you asking them to do something outside of their area of specialty? For me, that means if someone comes to me as GovCon, but it turns out it's only IP, I wouldn't do that work for them. Fortunately, the benefit of working at a large firm like mine is we do have an entire group of IP specialists. I would loop in one of my colleagues. They could help you out. So we could still do that scope of representation. However, if someone comes to me and asks me to help them in pursuing an unpaid $2,000 invoice, I would probably refer them to another attorney because I'm not the right fit. Being a government contracting specialist of a federal practice, my rate would shoot through that $2,000 faster than they could imagine. And to me, that's not providing value add. That means that somebody at the end of the representation is going to wonder why they even hired me, because they owe me more money, or they owe me just as much money, or nearly just as much money as they got out of it. So was there any benefit to the time and effort of going through the process and having me work on their behalf? More importantly for this discussion, though, is you. When you're reaching out to an attorney, often it's because it's stressful, it's frustrating, and you're hoping to get some resolution. I tell people, and it's always part of my French here, the last thing that you want is to have to pick up a phone as you're thinking, I have to talk to this asshole again. You want an attorney that you get along with well enough, that you don't worry about calling, that helps you, that you trust, and you want to work with them. That is what is essential. It's no different than your accountant. It's no different than any other professional service out there. When you call that person, you don't want to dread the fact that you're calling that person. You want to recognize that you have somebody in your corner that advises you and helps you and has your best interest to help your company grow and succeed. Attorneys should be invested in you for the long run. They shouldn't be looking to get one invoice out of you or two invoices out of you. Ideally, I get hired by somebody and I help them grow for 5, 10, 15, 20 years. And as they grow, they need me more. I get paid more. They get paid more. We're all happy because we're growing together and we're succeeding together. That attorney is invested in you, invested in your corporate strategy, invested in your business to help give you the best advice to be the best business owner and to be the best business you can be. What this means is ask questions. This can be you reach out to them by email saying, Dear Chris, I'm a service-disabled veteran-owned small business, a woman-owned small business, minority-owned small business, what have you. I think I may need assistance from a government contracting attorney, but I'm not sure. Do you have time to talk to me about that? That is a wonderful email to send, and I would immediately say, yes, please let me know when you're available. I'll find time to talk. You can also say, hey, Chris, working, got an NDA, have a few questions. Is that something you can advise with? Absolutely. That's a fine email to send as well. Don't send an email that's too broad of, like, Dear Counselor, have a business transaction. Are you available? To me, that screams like phishing and somebody who's not real and is trying to, scam me. You can also just cold call them. I've had that happen many times. I've had it, hey, Chris, I saw your training on termination for convenience. I'm going through that. Do you have time to talk about that? And then we talk about it. Or I say, hey, I'm in the middle of a Zoom or I'm walking into a meeting. I can't talk now. How about we talk in 1 hour, 2 hours, 3 hours, 4 hours? Those are all great ways to go about it. When you're doing this, though, and you're gauging if they're the right attorney for you, you want to ask them a lot of questions to find out if they're the right attorney for you. Many of those are on the very next page, but you want to ask, and when you're doing this, you can ask them something like, hey, can you recommend 2 or 3 other attorneys to me? And when they give you those attorneys, call those attorneys and say, hey, what can you tell me about Chris White? Is he a good attorney? Use that person's recommendations to find out what other people think about that attorney. There are different review websites. You can ask them questions about that. Ask them, am I going to be working with you, or are you going to bring me on and immediately have me working with somebody else? These are all things that you'll want to know. What's your preferred method of communication? I like email. Are you good with email, Chris? I like text. Are you good with text, Chris? I like phone calls. Are you good with phone calls, video, whatever? just get a feel for it, just to make sure that the person you're working with is going to communicate with you in a manner that you want them to communicate with you. These are all very important things to make sure you have a comfort level of working with that attorney. Finally, the red flags and considerations. As I said, this is meant to be not red flags like they're a shyster, they're a scammer, they're a bad attorney. These are red flags that the relationship might not be the right relationship with you or for you, for your business. What this means is you have an attorney, but maybe they're very hard to reach. You email them on a Monday saying, "Hey, Chris, I have an urgent proposal. I need to be done in 72 hours. When can we talk about it?" Monday, no response. Tuesday, no response. You burn 48 hours, and then maybe they get back to you. That's a red flag for you, because based on your business needs, that attorney may be too busy or may not respond in the manner you need for them to get back to you on time. That's similar to timely responses. If they're responding to you and making it so you have almost no time to submit a product on time, that's not a timely response. Attorneys can be very busy, just like all of you can be very busy. I could be in depositions for 12 hours and I can pop out and then I have to go debrief my client. During depositions, I won't be checking my phone for other calls, texts, or emails because I'm committed to that deposition, or I'm committed to that hearing or trial or what have you. But if I see something urgent came in, I will respond and say, "Sorry, I've been in depositions all day. About to go in and debrief with my client. Can I talk to you in 2 hours? Or can I talk to you at 8 a.m. tomorrow or 9 a.m. tomorrow?" Basically, obviously depending on what you told me when you need to talk. But we'll do that. And that's the response that you need. So you have comfort to know that you've been heard and that someone's ready to speak to you and ready to help you. Repeated typos, errors, mistakes requiring client correction. If I'm drafting a 60-page whatever for you, there will certainly be in the first draft errors, typos, mistakes. There shouldn't be many, but that's going to happen in a rough draft. What you shouldn't be seeing are mistakes requiring your correction where they're using the wrong FAR clause, where they're using the wrong language, where things that are very specific, very material are wrong, and you're catching them versus your client catching, or versus your attorney being correct in the first instance. Final products, though, shouldn't be errors, shouldn't be typos. That's where the attorneys had time to go through and clean it all up. So you shouldn't have to be the quality control on behalf of your attorney. You're paying them to put together a good, clean product. But they'll be asking you for input based on numbers and data and things that are your area of specialty as well. An attorney that presents themselves as an expert, but then you see large bills for significant time spent on getting up to speed. It's one thing if you're asking them to provide advice to you on the FAR clause, DFARs, etc. Those clauses change so often, they have to do some research to validate that the clause has not changed in the last 1, 2, or 3 months. They change so often. You'll see that. However, they shouldn't be billing you to get up to speed. That's arguably an ethical issue because we as attorneys are only supposed to take on matters that we are qualified and competent to represent on. So there's a difference between doing research into case law and doing research into the FAR clause to make sure that hasn't changed versus having to do significant reading in the background to even understand what is a termination for convenience or what is a bid protest or what are the filing requirements. That's stuff that specialists should already know. So you shouldn't have to pay someone to get up to speed. And that's sometimes where it's the difference between a generalist that doesn't do this work a lot and has to spend a lot of time digging into it to learn which FAR clauses are applicable, DFARs, which court rules, which GAO rules are applicable versus a specialist that already knows those things. So you want to keep an eye out for that. As I was saying, you don't want somebody who's not confirming the current state of the FAR and procurement rules. I tell people we do FAR flow down analysis all the time. Prime contractors and subcontractors, huge charts of FAR clauses. We're asked to let them know which ones apply to us based on this contract and what does that mean. I've done it where we had one client send it to us in January. My colleague had done it. Then I get asked to do it again in March. I pull up the same table because most of the clauses are repeated, but I find out a quarter of the FAR clauses were updated in February. If I had just trusted the data from January was still good, I would have been wrong, and my advice would have been wrong. So you need to do that research to understand that the current state of the FAR is constantly evolving, constantly changing. Same with procurement rules. Someone who's keeping their finger on the pulse for any change in the GAO about method of submission, time of submission, days of submission, for bid protests or contract claims. You want to have somebody who understands that's something they need to know right the first time every time. And then, as I mentioned, we'd be working directly with them or assigned to another attorney. At many firms, it's common that you get brought in by a partner or a senior attorney, and then they have a more junior attorney that bills a lot of the time to the file. This is done, A, to save you money, and B, for training for that junior attorney. That's not what I mean, because the attorney you hired is still supervising it, still reviewing it, still validating it, and still fully involved in the process that's going on. However, other times you get hired by attorney A and you like attorney A, they sound wonderful, but then you never hear from attorney A again because attorney B or maybe attorney C are the only ones who are talking to you. You don't have as good of a rapport with them. You don't enjoy speaking to them as much. So you start running into some issues there. You should know that up front. You should know who you're working with, and you shouldn't be confused as to why the attorney you thought you were hiring is not the attorney you're ever able to speak to or ever able to reach. Those are all things you want to consider and all things you want to be aware of for whether or not your current attorney is the right attorney for you, or whether or not your current attorney hits all the niches, hits all the areas and the wickets of what you need. And maybe you need to have multiple attorneys because your business is growing and you have multiple needs and multiple questions. Ultimately, it's a relationship. Just because you hired somebody doesn't mean you're committed to only staying with them. You're entitled to the attorney that you like and that you want to work with. And you're paying enough money, you're investing them enough that you want to make sure you have the right relationship with that attorney. As I said, no different than an accountant, no different than a consultant or marketing or business development. You want to work with somebody who's doing the right work for you and that you enjoy working with. With that, my final slide has my contact information, phone number, email, as well as a broad swath of areas of law that a government contract specialist does to keep people, abreast of it. And obviously, if you do need help or you do have any questions or confusions, don't hesitate to contact me. As NVSBC members, I do offer 2 hours of free work. So if you are an NVSBC member and you have questions about something like this, please don't hesitate to contact me. I tell people routinely, I would much rather someone contacts me. I give them some free advice. I never hear from them again because they somehow navigate the legal minefield from that point forward and don't need an attorney again, rather than finding out they were hesitant to reach out to me and stepped on a mine. And now their business is floundering or they lost their first big contract and a chance to break through. I'm here as a prior active duty, now Navy reservist, who wants to see other veterans succeed. And there are so many other people like me out there and as part of this great organization. So please reach out.
Chris, thank you so much. And thank you for the wonderful gift of 2 hours to the NVSBC membership. Listening to the presentation, it really is about, again, I know I've talked about this on several different Charlie Mikes, developing the relationship with the professional, because I want my GovCon attorney with me through my whole business journey. And I know you spoke about the red flags. A quick question, is there a time to break up with an attorney? I mean, if I see those red flags that you had in the previous slide, is usually my attorney will be able to grow with me? Is that normally the case? I guess that's kind of a question I would have.
Sure. It's a tricky question. That's a good question. And one that is going to be, as we learned day one of law school, the answer is always, it depends, right? And you learn that from every attorney. Yeah. So yes, your attorney certainly can and will grow with you. So that means, yeah, if one of these, quote unquote, red flags exists, bring it up to your attorney. Say, hey, I'm just a little frustrated, really hard to get a hold of you. Or when I finally do get a hold of you, it's too late and now I've missed a deadline or I've had to do it on my own. I need better responses because it's creating stress in my life. I'm not getting the legal representation I need. Be frank with your attorney. Let them know that's what's going on and hear what they have to say. Maybe they're like, oh crap, you're right, sorry. They grow with you, they improve, they do better. Or if they tell you, tough luck, that's how I do business, then maybe they're not the right attorney for you. I mean,
and you go, hasta luego.
Well, exactly. I mean, that's exactly right. I mean, you're paying people hundreds of dollars an hour to be there for you, to be an advisor, to mitigate risk, to theoretically take the legal off your plate so you can focus on some other area. And if they're not doing that, why are you paying them to do it, sort of thing? And so, I mean, I've had attorneys, I've had clients come and go. Most stay, but sometimes a client's like, you know what? I think I need either someone whose rate matches up more closely with me, or has a local office to where I am, or what have you. There's all sorts of reasons. It's no bad blood, no hard feelings. Like, I want you to want to be working with me. I don't want you to feel obligated to stay with me. And so, if someone brings a meaningful and accurate frustration to me, will I 100% take it on board, talk it over with them, and find out a way to improve with them so I'm giving them better service? Absolutely, I will. But you don't necessarily have to give them that chance. But sure, if you've gone through the process of engagement and you get to know the person, you want to give them the chance, by all means, give them the chance. But ultimately, to you, it's hard for me to tell them the right time to do it. But I mean, I think if an attorney is missing deadlines, would you let your employee keep missing deadlines and keep that employee on the payroll?
Yeah,
probably not.
That's probably not.
Your attorney is not your employee, but you are paying your attorney to do certain things for you, so they shouldn't be missing deadlines. On top of that, technically, if you miss certain deadlines to the attorney, that's a easy malpractice claim, and so that attorney shouldn't be okay with that either, because that missed deadline, you miss out on money. You can sue an attorney for malpractice because they failed to hit a deadline. And there's some intricacies into that, and I don't do malpractice law, but so that's why I say, like, it depends on when, like, if you really like that person and there's a couple small glitches and you want to give them a chance to improve, absolutely. If they've not been very responsive and they're ruffling your feathers the wrong way, and you don't necessarily have to give them a chance to improve, that's up to individuals and how they want to go about that.
It's kind of like, do I want this person as part of my business family, just like with my accountant, or, if I have an outside marketing person. Good. I'm glad you put that slide up, because I wanted everybody to get the contact info. And that, so this has been really great, Chris. And I know we have, just as FYI for everyone, we're going to have a few more topics from Chris on the legal aspects. And Chris also attends many of our regional engagement events, so kind of keep a lookout for that as well. And with that, I'm going to call this a wrap, and we'll see you soon, everyone. Bye-bye.
Thank you all.